judgment in the appeal, the Queen on the application of SG and others, and the Secretary of State for Work and Pensions.
Lord Reid will explain the decision of the Court.
In 2012, an Act of Parliament authorised the government to set a cap on the total amount of welfare benefits which a household might receive. The government then made regulations setting the cap and defining the benefits to which it applied. The regulations were approved by Parliament. The cap applies where the total entitlement of a single person or a couple to the relevant benefits exceeds the average weekly earnings of a working household in Great Britain, net of tax and national insurance contributions. The relevant benefits include housing benefit, child benefit, and child tax credit. The cap affects more women than men. That is because most non-working households receiving the highest levels of benefit are single-parent households, and most single parents are women. These proceedings have been brought by two single mothers and their youngest children. As a result of the benefit cap, the mother's weekly income was reduced. They challenge the lawfulness of the regulations, principally on the basis that the cap has an unjustifiably discriminatory impact on women in relation to their right to the peaceful enjoyment of their possessions, contrary to the European Convention on Human Rights. The courts below held that the regulations were lawful. The appellants now appeal to the Supreme Court. By majority, the Supreme Court dismisses the appeal. The reasoning of the majority of the court can be summarised as follows. It is conceded that the regulations affect more women than men, and that the benefits in question constitute possessions which are protected by the European Convention. The question is whether the cap is nevertheless a proportionate means of meeting legitimate aims. The aims of the cap are to set a reasonable limit to the extent to which the state will support non-working families from public funds, to provide members of households of working age with a greater incentive to work, and to achieve savings in public expenditure. The Court accepts that those are legitimate aims. As to the proportionality of the means, the appellants argue that the aim of setting a reasonable limit to benefits could be achieved by setting the cap at the average income of working households, inclusive of in-work benefits which they receive, rather than their average earnings, exclusive of benefits. That argument is rejected for a number of reasons, including that the Act itself requires the cap to be set by reference to earnings rather than income, and the Act of Parliament, as distinct from the regulations made by the government, is not and could not be challenged as unlawful. The appellants also argue that the savings in public expenditure are marginal. The majority of the court accept that the short-term savings are a small proportion of the total welfare budget, but note that nevertheless they contribute towards deficit reduction, and that the cap is also intended to change behaviour over the longer term. Other arguments focus on the impact of the cap on the families affected. The majority note that the cap for households with children is equivalent to a gross annual salary of £35,000, which is higher than the earnings of half the UK's working households. Whether the cap should be higher than that is, in the majority's view, a political question. They do not regard it as a function of the court to decide how much public expenditure should be devoted to welfare benefits. They regard it as important that affected households were given advance notice of the reduction in their benefits and were offered assistance to enable them to adjust. Another argument focuses on the impact which the cap may have upon children in the households affected. It is argued that the cap is incompatible with the rights of children under the UN Convention on the Rights of the Child. The majority of the court do not, however, regard that issue as relevant to the question whether the cap breaches the rights of women not to be discriminated against under the European Convention. The UN Convention does not itself form part of UK law. Another argument is that the greater impact on women could be avoided or reduced by excluding child-related benefits from the cap. Excluding these would, however, reduce the savings by around 80 to 90% and would therefore compromise the achievement of the cap's aims. No credible means have been suggested by which those aims might be achieved without affecting more women than men. Generally, the majority consider that the question of the proportionality of a cap involves controversial issues of social and economic policy with major implications for public expenditure. In relation to matters of that kind, it is accepted that the court should not interfere with the assessment of democratically elected institutions unless it was manifestly without reasonable foundation. Most of the issues in the appeal were considered in Parliament. The government's view, endorsed by Parliament, was that achieving the aims of a cap was sufficiently important to justify making the regulations, notwithstanding they're affecting more women than men. The majority of the court conclude that that view was not manifestly without reasonable foundation and should therefore be accepted by the court.